number 44, Lynch versus the City of New York. Counsel?
Thank you, Your Honor. The point I want to emphasize, of course, I'm going to start with the text of the statute, which says, any member who is absent without pay for child care leave shall be eligible for credit. And nobody disputes that member means member of the police pension fund. But the city reads the language to say any member in Tier 1 or Tier 2, but not Tier 3. And that's flatly contrary to the text of the statute. And I think it's fair to say that essentially the only basis the city has for the way it reads the statute is the theory, which comes up over and over again in their brief, that Article 14 of the Retirement Social Security Law, the Retirement Social Security Law, is the exclusive source of benefits for Tier 3 members. They say that when the 2000 legislature, and this was a bill passed in 2000, when they passed that statute, the legislature must have understood that if they wanted to give a benefit to Tier 3 members, they had to do it by amending the RSSL in Article 14. They couldn't do it by amending the City Administrative Code. Now, I would say that even if the legislature, there was some evidence the legislature thought that in 2000, I would argue that it could not overcome the plain text of the statute. But if the 2000 legislature did not have this understanding, and there's no basis for attributing that understanding to the 2000 legislature, then I think the city's case collapses completely. And I'm going to argue that there's no basis whatever for attributing to the 2000 legislature the idea that Article 14 was the exclusive source of benefits. The only statute or statutory text that the city relies on for this their exclusivity theory, the theory that you've got to go to Article 14, is 519(1) of the Social Security Law, the Retirement and Social Security Law, which is on page, I quote it in full at page 4 of my reply brief, and it just won't bear the meaning that the city gives it. There's no way to read that statute as an exclusivity statute.
Mr. Smith, do we need to look at the sponsors' memorandums, particularly the 2005 amendment here?
Okay. I'm sorry. It's very hard for me to tell who's talking. Is Judge Garcia?
No, it's Judge Fahey. No, don't worry about it. It's the mass. Everybody's had the same problem.
I apologize.
It's no problem.
Your Honor, the 2005 memorandum would be, I think, be more relevant if you're interpreting the 2005 statute, but I would like to talk, since you brought it up, about what happened 5 years after, and to me more important, 4 years after this law was passed. This one was passed in 2000. And then there's a little drama in 2004 and 2005 involving the corrections officer, which is a very major point of my adversary's reliance. May I say in parenthesis, he does that because there's nothing before 2000 that could possibly support. And I mean, he says that there are things that do support it, but they don't. But what he has to rely on primarily is what happened afterwards, and that's a weak point to begin with, because how does that prove what the 2000 legislature thought? But it's weaker than it looks. What happened was, in 2004, the legislature, everyone agrees, wanted to give a benefit to all correction officers, including Tier 3. So it did so by amending the administrative code. And the city says, well, there was an oversight. They made a mistake. They didn't do what they intended to do. What was the oversight? The oversight was that the 2004 legislature didn't know that they had to amend Article 14. Well, if they didn't know it, how are we supposed to think the 2000 legislature knew it? How are we supposed to believe that any legislature before 2005 had any idea that they were supposed to amend Article 14 of the Administrative Code?
I see the plain language argument, but what I wonder here is the appellate division seemed to rely on the concept that there was a conflict between the Administrative Code and the RSSL. Why don't you address that issue?
I don't think there's any conflict at all. The Article 14 doesn't have a child care benefit in it. There's only a conflict if you accept the premise that it doesn't, that an exclusion from Article 14, that anything that's not in Article 14 is excluded. And that's not right. We have counterexamples. There's a variable supplement fund that's not in Article 14 that applies.
Counsel, what about in 519, the effect of other laws provision that says provisions of the administrative code relating to procedural matters shall apply to Tier 3 members covered by 14?
Yeah, that's where I was going a second ago, Your Honor. That's a statute of inclusion, not exclusion. It says these things shall apply. The city's brief puts the word only there, but not in quotation marks, because word only isn't in the statute. 519 is an incorporation by reference statute. It says, in substance, we don't want to type everything from every other statute that's going to be just the same for Tier 3 as for everybody else, so we hereby incorporate it by reference. And that's all 519 does. And I think that's why my adversary didn't quote the full statute in his brief. If you read the whole statute, any provision of this chapter or the state of several things, including the New York City Administrative Code, shall apply to members covered into this statute if it relates to certain subjects. That's all it says. It says shall apply. It doesn't say anything shall not apply. It doesn't say the only way to amend this is by amending Article 14. If it had said that, by the way, it would be ineffective because you can't bind future legislatures. That is, if they had said no future legislature may amend this statute except by doing a certain thing, the next legislature could say, sorry, we don't agree, we're amending it any way we want. But that doesn't come up. This is not, this is purely an incorporation by reference statute. It is not an exclusionary statute. It's never been read as being an exclusionary statute. There is no case anywhere, in fact.
There's also sort of the strain in the city's papers, I think, that when any member was written, there were no Tier 3 members, and the city knew that, and so it was meant to apply only to Tier 1 and Tier 2.
Actually, I don't think that's at all logical, Your Honor. First, of course, Tier 3 did exist, and the possibility of applying it to Tier 3 members was very, very much alive. They had to, every 2 years, they passed the law excluding Tier 3 members. And in any event, when you pass, the statute says any member of the police force, if you're going to, or any member of the police pension fund, is what it means. If you say any member of the police pension fund, the only natural interpretation of that, absent some other very strong reason, is any past or future member in any tier, even the tiers that haven't been created yet. Even if they'd never heard of Tier 3, if they were going to say any member, they can be understood as meaning any member. If they want to say any member who's a member today, that's different. Then you wouldn't get to Tier 3. But if you say any member of the police force shall get a badge or a cost of living adjustment or anything, it means any member of the police force. It doesn't mean just the tiers that happen to exist at the moment, even though Tier 3 did exist at the moment in 2000 and was entirely possible and something the legislature must have been deemed to have understood, that it could apply to police officers. So I just don't think the city even gets to first base unless you buy the idea that there is, which I think is an urban legend, that that you have to amend Article 14 if you're going to give any benefit to Tier 3 officers. No case has ever said that. No statute has ever said that. No legislative history within 5 years of that is until 5 years after the 2000 legislature passed this law had ever said that. And the 2004 legislature obviously had a completely contrary understanding. I guess my time is up.
Thank you, Counsel. Counsel?
May it please the court, my name is John Moore and I represent the City of New York and the New York City Police Pension Fund. The legislature has made clear that it neither understood nor intended the child care service credit benefit to apply to Tier 3 police officers.
But counsel, if we're thinking, I understand your adversary's argument to be, look at the plain language of the statute, it's passed in 2000. I understand that argument. I think, does your argument have to be, when they passed that statute in 2000, the legislature intended that only to apply to Tier 2 members, knowing that every 2 years, this thing had the possibility of rolling over into Tier 3. But that was their intention in 2000.
That's correct, Your Honor. That it was,
What in the record indicates that?
what indicates that is that it was included in the administrative code, but not in the retirement and Social Security law in Article 14. There are numerous provisions in the administrative code that only apply to members, the key term here, but only apply to members in Tiers 1 and Tier 2. And I want to draw the Court's attention to the 2014
Wouldn't you have
decision.
to look at each of those provisions and understand what it does and what was in effect when that provision was passed? But in this case, we know it was 2000. We know that there was the potential for rollover. We know the intended benefit. And I have a hard time constructing a legislative intent here, if we're going to look for one beyond the plain meaning of the statute, that says, we only intend this to apply as long as you're in Tier 2, and as soon as there's a rollover, you're going to lose this benefit.
Well, there's numerous places to look, and one of which is that the prime example that I would point Your Honor to is that the legislature understands the structure of the pension system that is enacted. Now, it's a complex system. It's been amended piecemeal over decades, which is why this Court has always been clear that it adopts a very holistic analysis and interprets the statute as a whole. In doing so, you have to look at Section 519, which defines the effect of other laws. Now, the PBA claims that that's a statute of inclusion, that it expressly includes the transfer of members and reserves between systems, the reemployment of retired members, and procedural matters. Then under the PBA's reading, it also includes and everything else. But by specifically naming those three areas, those three categories, where the administrative code does apply to Article 14 members, it is by implication excluding things that don't fall within those three categories.
Let me address that argument, one of my difficulties with it. The way I see this, if we just stick to the plain language argument, I don't think the plain language argument favors your point of view, but reasonable minds can differ about that, however. But what I'm wondering is it seems that you're arguing that the administrative code that was enacted in 2000 is repealed by an RSSL Section 15H, which was enacted in 1976. Does that make any sense?
Well, that's incorrect, Your Honor.
Okay.
And the reason is that the administrative code provision is not repealed at all. It continues to apply for Tier 2 and Tier 1 members. At this point, I suspect there are no Tier 1, but it does continue.
Wouldn't a court say that what we should be trying to do here is reconcile these, is read them together?
That's correct. And the way that you do that is by reading the administrative code to apply to Tier 1 and Tier 2 members, and Article 14 to apply to Tier 3 members. And I don't want to return...
back in plain language territory. That's the problem there.
Well, so if I may, Your Honor, I'd like to
Sure.
return to this Court's 2014 decision in Lynch, because I think that it addressed many of the issues that are being questioned in this appeal, and because the rendition of that from the PBA does not accurately reflect what the Court decided. In 2014, the Court was considering an increased take-home pay benefit that was granted in the administrative code to members in Section 13226. It was a temporary benefit that was eventually made permanent during the pension reform measures of the mid-'70s. And so that was extended and then made permanent. It was made permanent, by the way, after Tier 3 members, after Tier 3 had been created. In doing so, however, this court held that in making it permanent, it made it permanent for those members who were already entitled to receive it. It didn't expand the scope of those members. So the question became, are Tier 3 members, are Tier 3 police officers eligible to claim that benefit? Supreme Court, when it ruled on this issue, said, statute says members, Tier 3 are members, that's the end of the analysis. This court, however, rejected that reasoning. This is the language in the Lynch decision that says that in order for a benefit, even one applying to members, to apply to Tier 3 members, it has to be included in Article 14.
But this one doesn't have that same language. And that language is very distinctive from what's in this case. So, I mean, I think Lynch recognized that the benefit, was set forth in the code. I guess my question is if the legislature in this case, without any language like that, intended to limit it to Tier 2 members, why didn't they just put it in Article 11?
The reason for that, and if I may, 2 points on that, Your Honor. The first is that Article 11 primarily serves as limitations on the benefits to Tier 2 and Tier 1 members. Primary benefits are granted in the administrative code, and that you can actually still see that today. Last spring, on May 30th, the governor signed into law Chapter 89 of the laws of 2020, and that created a accidental death benefit related to public employees who contracted COVID, presumably during their work as public employees. In amending that law, which also applies to members, again, the key term here, the legislature added the benefit to 4 chapters of the administrative code for police, fire, teachers, and New York City Employee Retirement System, not Article 11, but then also into 4 chapters of the Retirement and Social Security law. When the legislature wants to apply a benefit across tiers, it knows how to do so, and it does so by amending both the administrative code and the Retirement and Social Security law.
That logic applies to repealing an action also, and it seems to me that, to follow up on Judge Stein's point, is that you're arguing for repeal by implication rather than explicitly.
No, Your Honor, again, it's not a repeal because the statute remains in effect in full force for the members for whom it has always applied, which is Tier 1 and Tier 2 members. If a Tier 2 member today...
Yeah, you suffer there from the any language, any member problem, though. But I have your argument. Thank you.
On that, Your Honor, I would direct your Honor's attention to the Lynch decision, to the amendments to the administrative code and the Retirement and Social Security law relating to any correction member, and the Worthon decision.
But in Lynch, and I may have the facts wrong, I'm sorry, but in Lynch, wasn't the original statute passed before Tier 3 existed? Or is that not so?
That is correct. The original statute in the administrative code was before Tier 3.
Yeah.
It was subsequently amended during the process by which the new tier was added. But similarly here, the benefit was added before there were any police officers in Tier 3.
But it existed and there was a foreseeability that they would be rolled into that. I think they had to do it every 2 years. But so it strikes me as somewhat different than Lynch. When they drafted that provision, there was no Tier 3.
That may be the case, but I would say that the fact that the legislature was aware that one day Tier 3 officers could become members, or that police officers rather, could become members of Tier 3 actually favors us, because we know that that they can amend the Retirement and Social Security law, Article 14, when they want to add that benefit. That's what they did for correction members. In 2012, they had the opportunity to do so. They said, we've realized that police officers aren't entitled to this benefit, and rather than grant it to police officers, they canceled the benefit for newly hired correction members. That indicates that the legislature both didn't understand police officers to have it, they understood the structure of the system that they were working within, and didn't intend for Tier 3 police officers to be able to claim that benefit. I want to address one additional point, which is that the PBA cites to a variety of administrative code provisions that it says indicate that substantive benefits can in fact come from the administrative code for Tier 3 members. I would suggest, Your Honor, that that's simply untrue. And the variable supplement fund that the PBA specifically highlighted today actually makes clear that it's not actually a pension benefit. If you look to Section 13269B, the statute says this is not a pension benefit. Payments from this fund don't count as pension payments. So to say that that indicates that substantive pension benefits can be granted to Article 14 members through the administrative code simply doesn't hold true. On a broader scale, the fact is that Section 519 creates a default rule. It says, here's how these statutes ought to be interpreted together, and it doesn't include substantive benefits. To the extent that an occasional procedural issue, which is the bulk of the statutes that the PBA cites, take a hyper-cautious approach and say, well, this transfers of funds, the payments that employers have to make into different interest rates, that doesn't apply to Article 14 members. First of all, that's a procedural matter. It's arguably within 519, and it doesn't overturn the entire pension structure. The PBA's argument would upend that structure and say that the Article 14 is not the source of Tier 3 benefits, that 519 ought to be read to incorporate everything, and that any member, contrary to the legislature's understanding and this court's interpretation, transcends tiers, which is, again, is simply not what this court or the legislature has ever understood that term to mean.
Thank you, counsel.
I think I neglected to reserve rebuttal time, Your
I
Honor.
reserved it for you, sir.
Thank you. How much did you reserve for me?
2.
2 minutes, thank you. I guess I should, maybe I'll deal first with the idea that the supplemental pension benefit, the variable supplemental benefit isn't a pension benefit and therefore could be done without amending Article 14. That is real hair splitting, Your Honor. It's not a pension benefit, it's a supplement to a pension benefit. You can't seriously say that, oh, if you want to amend the pension benefits, you've got to go to Article 14, but if you want to supplement the pension benefits, anything you like, the administrative code is fine. No one could understand a system that complicated, and there's no basis for it. It's essentially made up. The real difference, to the extent there is one, and I'm not saying you can make a totally consistent whole, because these things do get confusing. The retirement social security law on the whole is tier specific. It has an article for each tier. The administrative code is fund specific. You've got an article for the police, an article for the firemen, an article for the firefighters, an article for the corrections officers. If you're trying to do something for police and not for every city, not for every employee in the state, the natural place to go is the administrative code. And I think that's why the administrative code was used here. There are other things I could say, but I think maybe the thing I really want to say is an old saw I learned in law school. If the legislative history is confusing, I don't think it's all that confusing, but if the legislative history is ambiguous, you're not forbidden to look at the statute. But I suggest you look at the statute.
Thank you, counsel. Okay. Thank you all.